Steve, let me ask you. You said that copyright's dead in this type of situation, but there was a period. I believe there were all three of them or four of them actually in 2014, where judges rejected motions for summary judgment or motions to dismiss. It was like a blip on the horizon.
Yeah, a little glimmer of hope there for a while. Yeah.
But now they've gone back to just dismissing them summarily.
Right.
One of them was the Dillon case. I know you wanted to talk about that one. What distinguished that case from the avalanche of other cases that were dismissed out of hand before it?
Better judge. Different judge.
Okay.
Christina Snyder has also come in on some cases favorably. I forget the other judges in the United States District Court who are appearing to be pretty fair on these cases. But it's weird. It seems like Judge Wilson gets a disproportionate number of these cases, as does Judge Morrow. It's just very strange. And if it goes to, well, Judge Morrow has resigned from the bench, of course, but or stepped down from the bench. But yeah, I think that's the only difference. Some of these cases, one of them, as you know, the Frozen case was in Northern California. And so you had a theoretically fair and unbiased judge, in my opinion. And then the other one was, I guess, Judge Dillon versus NBC is Judge Otero. Yeah, Judge Otero in the Central District. So it's, yeah, I just think it's a different judge.
Can I respond to that?
Sure.
So, I mean, the one inference you might draw from this is that there's a conspiracy of the Ninth Circuit and district court judges of the Ninth Circuit to screw plaintiffs in copyright cases. And particularly, there's several of them that in particular are hostile to plaintiffs in copyright cases. And these gentlemen argue cases in front of these judges, so they may have a better subjective sense of that than I do. All I know is from reading the decisions. I don't litigate cases. So that said, the other inference one could draw from this observation or this data is that the studios aren't infringing copyrights. The cases are bad. My first job, while I was working in law school, I worked at a record company, Arista. In my first few months of work, we got a letter from someone who literally claimed to have written every song Barry Manilow sang. Not that I cared, but obviously he didn't. My next job, we got a letter from a guy who said, I've just been released from a mental institution. I had worked in the theater before that, and I realized that Chorus Line was stolen from me, and I created it. When I worked at Fox, although I didn't directly handle copyright infringement cases, often the transactional lawyers would get involved in a case where works that we were developing, we had worked on works that were developing, and there were assertions of copyright infringement. Virtually all of those were gotten rid of on the basis of access and prior creation. There's a lot of bad cases out there, and this somewhat similar ideas have come up in some of the 8 or 9 cases against Jim Cameron for Avatar. It seems like the cases against a movie vary proportionately to the gross box office receipts of the movie. Avatar has attracted, 6, 8 of them?
7 cases.
So apparently Cameron ripped off that story from 7 or 8 different people, but they got in front of a bad judge who hated the plaintiffs, and so and on Dillon, I wanted to say on Dillon, the case that you mentioned. Dillon, and it was in the Northern District of California, so we don't know whether it proves or disproves the assertion that the Central District is particularly hostile to these cases. The Northern District is pretty hostile to copyright plaintiffs when it comes to internet intermediaries, but that one was, fairly implausible too. Although what happened in that case, that involved a guy that created a reality show idea based on celebrities facing military challenges. So I just described them as being exactly similar, right? They both involve celebrities facing military challenges. Is that an infringement? No. It went beyond that. The court looked at all the various elements they look at in comparing literary and audiovisual works, and they found sufficient similarities, including a very strikingly similar set of what you might call characters, if it had been a fictional work, participants in the show, that they felt they couldn't dismiss the case. So, you know, it was to me, though, a lot of the similarities they found were really kind of ridiculously scenes-à-faire when it comes to reality shows. There's a competition, people are thrown off, etc. Just the commonplace, you know, scenes-à-faire, I guess you'd call them, in reality shows. But the one thing that was, you know, I think was maybe more persuasive to the court was that these characters, there were some identical or virtually identical characters or players that the plaintiff had suggested for his show that the defendant had used in their show, and so the court didn't dismiss it. I'll be shocked if that case results in a success for the plaintiff.